is supported by our media partner, Live.in. We are honored to have with us Hon'ble Mr. Rajiv Prasad as state speaker for this workshop. Your Lordship has completed Bachelor of Degree from Campus Law Center, University of Delhi in the year 1991, and thereafter has started his legal practice at Patna High Court. Your Lordship has diverse area of practice in civil matters, commercial law, service matters, and criminal matters. Your Lordship has also represented his clients before different forums, including tribunals, different high courts, and Supreme Court of India. Your Lordship has worked for several central and state government organizations such as Bihar Industrial Area Development Authority, Infrastructure Development Authority, Bihar State Tourism Development Corporation, Bihar Economic Office Unit. Your Lordship has elevated from bar to bench on 22nd May 2017. Since then, he has delivered numerous remarkable judgments on various laws. Now, I would like to request Advocate Ashik to kindly present a token of gratitude to Hon'ble Mr. Justice Rajiv Prasad. Now I would like to request Editor-in-Chief of our legal magazine, Advocate Soni Srivastava ma'am, to give insight on our next publication.
Our guest of honor today, Hon'ble Justice Rajiv Prasad, our patron, recognized Mr. Rebecca Sharma, all the members of the Federation and all other esteemed colleagues and guests who are present here today. I feel honored and we are taking this opportunity today to have our second edition of our magazine called Samatva, which was released on the day this Federation, Bihar Federation of Women Lawyers was born. So on that day, we had released the first edition of our magazine. We were in a haste, no doubt, but we thought we were not going to miss this opportunity when Hon'ble Justice Rajiv Prasad is here. So we have somehow managed to get a soft launch of the magazine done and inaugurated by Hon'ble Justice Rajiv Prasad, by our guest of honor today. Before going on to the launch of the magazine, we are only just in very brief let you know that this magazine incorporates some articles written by some very young lawyers also who have written on some very relevant and contemporary topics. Then there's a legal reporting team who has put in all their efforts for reporting the recent judicial pronouncements given by the Honorable Apex Court and also by the our own Honorable Patna High Court. We then have a section in which we take a journey of some legendary figure, and this time Justice Sanjana Prakash, a former judge of Patna High Court who's practicing right now in the Honorable Supreme Court. She has been kind enough to give a write-up, a story on her journey from a lawyer to a judge and then again a lawyer in the Supreme Court. Besides this, we also have a section on life of a legend, on which we have tried to pay a tribute to late Justice Fatima Bibi, a face whom the Indian judiciary has lost, and this loss is truly an unbearable one. But we have tried to pay our tribute in our little way. We have also covered the creation of district units of the Bihar Federation of the Women Association, and with the efforts of our very dynamic office bearers, I must say, They have taken all their efforts to create these district units, and not only that, we have also tried to cover our other achievements like numerous workshops and seminars, etc., which we have done in a very short span of time, thanks to the cooperation and active participation extended by all the members of the Federation. And last but not the least, this magazine acknowledges the valuable contribution of our patron, our dynamic office bearers, our very young and talented volunteers, both for the workshops and for the magazine. And I really thank everyone present here. I may now request Siddhi, Advocate Siddhi, to, oh, I think it's already there, the folders which are there before my lord, and Mr. Devka Sharma. So since we are only doing a soft launch, I would request that the folders be opened, sir. The folders be opened by both the dignitaries on the dais, and it may be revealed. We can have a, we can just stand up and this is the front cover page of the magazine. So with this, I think we have done a launch, a formal launch, a formal inauguration of our second edition of the magazine. Thank you so much, Honorable Justice.
Thank you, ma'am. Our today's topic is Bharatiya Nagrik Suraksha Sanhita 2023. Bharatiya Nagrik Suraksha Sanhita 2023 seeks to replace the Code of Criminal Procedure 1973. We embark on a digital transformation of Indian justice system through this law. Now, I would like to humbly request our guest and esteemed speaker, Hon'ble Mr. Justice Rajiv Prasad sir, to enlighten us on today's topic.
A lot of thanks for organizing this workshop. In fact, if I say that I feel privileged to be here, it would not be wrong. I am with the lawyers' friends, the professionals who are really the stakeholders of this institution. And it is they who are always instrumental in making the institution. I am a part of that. So I really feel humbled and giving me an opportunity to be here with all of you. It gives me immense pleasure to be present on this occasion. Today we are going to discuss what are the changes in the Bihar Nagrik Suraksha Sanhita, which is presently known as Code of Criminal Procedure. In short, I will call it BNSS. There are structural changes which we will notice in this workshop. Simultaneously, we will notice what are the new provisions which have been added in the BNSS. What are those provisions which have been deleted, and then how the new BNSS envisages the investigation of the criminal case, the inquiry and trial. I have briefly noted some of the structural changes which have taken place. And I will part with you this writing which I have prepared later on. Some of you can take a soft copy of it. This I have prepared on my own after reading the entire book and comparing the CRPC and the BNSS. So, BNSS replaces the Code of Criminal Procedure 1973. In BNSS's 92 new sections, clauses and subsections have been inserted. 92, not only sections, there are only 9 new sections, but new sections, clauses and subsections. Altogether, there are 92. 177 sections and clauses have been modified. 14 sections have been deleted. And at about 39 cases, you will find that audio, video or electronic means have been introduced. Altogether, 14 sections have been deleted. And in place of 484 plus 51, why I say plus 51? Because in the original CRPC there were 484 sections. Later on, by way of amendments, 51 sections were added. So, presently it is 484 plus 51. In 37 plus 2 chapters. Again I say 37 plus 2 means those 2 chapters were added later on. Earlier it was 32 chapters, 37 chapters. Now the BNSS, see the structures in this have taken place. In case of 484 plus 51, now there are 531 sections and 2 schedules in 39 chapters. 9 new sections have been introduced, whereas changes have been effected in 160 existing provisions. 364 sections have remained unchanged. So these are the brief note of the changes which have taken place. Now what are the structural changes? Sections 1 to 5 falling under chapter 1 of CRPC is now retained at chapter 1, section 1 to 5. In the definition section, 2 new sections such as audio, video, electronic means, section 2 clause A, bail bond and electronic communications have been added. These words were not defined earlier. Now these words have been defined. An electronic evidence, an electronic device including the telephone, mobile phone or other wireless communication device or a computer or audio player or camera would be covered within the meaning of words electronic communication. In chapter 2 now the concept of metropolitan magistrate as contained in section 8 CRPC has been abolished. And court of session, section 9 CRPC is now changed to section 8 of BNSS. Subsections 7 and 8 have been inserted to section 8. Now the session judge may make orders as to distribution of business among such additional session judges, and he may also make provision for the disposal of any urgent application. In the event of his absence or inability to act by an additional session judge, or if there is no additional judge, by the chief judicial magistrate. Therefore, this power has been now vested with the district and session judge. Now, section 21 CRPC has been changed to section 15, which talks of appointment of a special executive magistrate. Now, a police officer not below the rank of the superintendent of police or equivalent may be appointed as a special executive magistrate by the state government. So, a police officer not below the rank of superintendent of police or equivalent, he may be notified as a special executive magistrate. Section 29 subsection 2 CRPC is now section 23 subsection 2. In subsection 2 and subsection 3, now a magistrate of the first class may pass a sentence of imprisonment for a term not exceeding 3 years or of fine not exceeding 50,000. So what is the change? Earlier this amount of fine which he could have imposed was rupees 10,000 only. Now this fine amount had been increased, and now a magistrate of first class can impose a fine up to rupees 50,000. Similarly, under subsection 3 of section 23, a magistrate of second class may pass a sentence of imprisonment for a term not exceeding 1 year or a fine not exceeding 10,000 rupees. Earlier it was only 5,000 rupees. Now this 5,000 has been increased to rupees 10,000. Under both the subsections, the magistrate of first class and second class have been empowered to pass an order of sentence of community service. Till now, we were talking about the community service sometimes while passing bail orders. Some of us were imposing certain conditions which were in the nature of community service that had no sanctity of law. But now in the new criminal law, in BNS, Bharatiya Nyaya Sanhita, there are at least 6 offences in which this community service has been incorporated as one of the punishments. 6 offences. So, now CRPC, what CRPC does, this BNSS defines community service. What is this community service? Though still there are something lacking in this, that how this community service punishment is to be regulated by the court. That machinery is not provided under the CRPC. But CRPC provides for empowering the magistrate of first class and second class to pass an order of sentence of community service. It says the community service shall mean the work. What is community service? It shall mean the work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remuneration. इसलिए अगर कहीं किसी को पनिशमेंट दे देंगे साहब आप तो अगले 7 दिन तक इस फुटपाथ पर झाड़ू लगाना होगा, तो that will be a punishment. And why it will be punishment? Because you would not be entitled for any remuneration for that service. It will be a service to the community without remuneration. That will be his punishment. Now, chapter 4 of CRPC deals with section 32 to section 34. And these provisions provide for the powers of superior police officers and burden upon the public to give information of certain offences. That you can see under these sections, certain burden have been imposed upon the public, that is these kind of offences you have to provide information. That is already there presently also, that provision is there. Now regarding arrest of persons, it's a very important issue which we have been discussing all the times. Chapter 5 of BNSS, which is providing for section 35 to 62. Chapter 5, under which section 35 to 62 are there, contains the various provisions related to the arrest of the persons. We have been talking about section 41, notice under section 41. Now it is section 35. So section 41 CRPC is now section 35. This provides when a police officer may, without an order from the magistrate and without a warrant, arrest any person. Section 41 CRPC had been arranged and changed to section 35, subsection 1 and subsection 2. So in BNSS, section 41 had been arranged. Now it is section 35, subsection 1, subsection 2. And then one subsection 7 had been inserted in section 35, which says that, quote, no arrest shall be made without prior permission of an officer not below the rank of deputy superintendent of police in case of an offence which is punishable for imprisonment of less than 3 years, and such persons is infirm or is above 60 years of age. So in the BNSS, an attempt had been made to deal with such situations where an offence alleged against a person is punishable for less than 3 years. Then in such offences where it is punishable for less than 3 years and where the person is infirm or above 60 years of age, no arrest shall be made. The sentence starts with the word no. So it's a mandatory provision, and it says no arrest shall be made. We know the rule of interpretation, no followed by shall makes it mandatory. Therefore, without prior permission of the deputy superintendent of police, in such cases no arrest shall be made. This is new, inserted under subsection 7. Now section 41A of CRPC, notice of appearance before police officers. These provisions are now contained in subsection 3 and subsection 6 of section 35. According to this provision, a police officer shall, in all cases where the arrest of a person is not required, under subsection 1, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence to appear before him or at such other place as may be specified in the notice. Under subsection 5 of section 35, where such person complies and continues to comply with the notice, he shall not be arrested. All of us have read the judgment of the Hon'ble Supreme Court in Arnesh Kumar vs. State of Bihar, recently retreated in Satyendra Kumar Hantel's case. So, the legislatures are taking note of those judgments while arranging section 41A. Care has been taken to incorporate all such safeguards in the matter of arrest which have been provided by way of judicial pronouncements by the Hon'ble Supreme Court. So you will find this subsection 5 of section 35 is again an attempt to fall in line with the judgment of the Hon'ble Supreme Court. Now, about medical examination. Section 53 CRPC is now section 51 of BNSS. The change is that earlier medical examination would have been done at the request of a police officer not below the rank of sub-inspector. Now this condition has been abolished. Now, on the request of any police officer, this medical examination shall be done. So this embargo has been lifted. Then subsection 3 of section 51, this is now a provision which casts a duty upon the medical practitioner to forward the medical examination report to the investigating officer without any delay. You must have noticed sometimes we come across cases where the IO will say that sir, where injury report नहीं मिला. Now the BNSS mandates it under subsection 3 of section 51 that the medical officer has to forward the medical examination report to the investigating officer without any delay. So they have been made accountable. Now chapter 6 deals with the processes to compel appearance, section 63 to 93. There is a change in section 61 CRPC, which is now section 63 of BNSS. The form of summons issued by a court shall be in writing, in duplicate, signed by the presiding officer of such court. Now a new provision has been inserted in this regard. What is that new provision? It says, now a summon issued by the court may be in an encrypted or any other form of electronic communication. This was not there earlier. And shall bear the image of the seal of the court or digital signature. So the summon of the court may now be communicated, may be issued in form of an electronic communication. What will be required is that it must bear the digital signature of the court and it should have the image of the seal. So this is a new provision which has been now brought into effect. Now regarding the service of summons, section 64 of BNSS contains a provision wherein a police station or the registrar in the court shall maintain a register to enter the address, email address, phone number and such other details as the state government may by rules provide. So now the state government has to frame rules. In order to implement this section 64 BNSS, the state government has to frame rules. Provided to section 64(2), subsection 2 of BNSS says that the summons bearing the image of court seal may also be served by electronic communication in such form and in such manner as the state government may by rules provide. So again, in what manner it has to be served? The state government has to frame rules. We will have to see to implement these provisions. The state government will have to come out with the rules. Now section 69 CRPC is changed to section 61 BNSS. And the words summons to be served by electronic communication have been added in section 71(1) of BNSS. The words number of all such summons by electronic communication are added in section 71 subsection 2. I said at the outset that at about 39 places. Now changes have been made to incorporate the issuance of summons, service of summons, then inquiry, course of inquiry, investigation, and then search and seizure. The use of electronic means have now been incorporated in the statute. So, this is one of the provisions which had been amended, section 71, to incorporate that summons to be served by electronic communication. Now then another change is regarding proclamation and attachment. Section 82 CRPC changed to section 84 BNSS. 82 all of us have heard. Kurki Japti 82, 83. Now 82 has been changed to section 84 of BNSS. According to subsection 4 of section 82, now where a proclamation published under subsection 1 is in respect of a person accused of an offence which is made punishable with imprisonment of 10 years or more, or imprisonment for life or with death under the Bharatiya Nyaya Sanhita 2023, or under any other law for the time in force, and such person fails to appear at the specified place and time required by proclamation, the court may, after making such inquiry as it thinks fit, pronounce him a proclaimed offender and make a declaration to that effect. Earlier, you see the present CRPC. There are only certain sections. If somebody has committed offences under those sections, then only this proclamation is to be made. But now this proclamation may be issued in all such cases where the offence is punishable with imprisonment of 10 years or more. So this is a change in the provision. Now a new section 86 has been inserted. It has been added in BNSS, which provides for identification and attachment of property of proclaimed person. This is a new provision, very important provision. All of you will have to argue one day or another this, because large number of cases are likely to be dropped up by virtue of this section 86. It says, under this provision, on the request of police officer, not below the rank of superintendent of police or commissioner of police, initiate the process of requesting assistance from a court or an authority in the contracting state for identification, attachment and forfeiture of property belonging to a proclaimed person. Suppose activities of the state of Bihar. He is being tried in the state of Uttar Pradesh. Now there was no provision how to identify his assets in the state of Bihar. Now a special provision has been incorporated, and under this provision the superintendent of police or commissioner of police can initiate the process of requesting assistance from a court or an authority in the contracting state. वहाँ ये फाइल कर देंगे petition for identification, attachment and forfeiture of property belonging to a proclaimed person. So now it will be easy to catch hold of those persons who are absconding and are having property in another state. This is section 86. Now chapter 8. I don't know कितना time आप लोग रखते हैं इसको.
Sir, please continue.
Because I am in habit of speaking more. So, chapter 8. Processes to compel the production of things. Section 91 CRPC changed to section 94, which provides for summons to produce document or other things. In the new provisions, the words electronic communication, including communication devices, which is likely to contain digital evidence, have been added. The words quote, in physical form or in electronic form, unquote, are added in subsection 1 of section 94. Again, emphasis is on electronic communication, digital records. Section 105 of BNSS is again newly added provision, which provides for recording of search and seizure. Also, this is a big safeguard. According to me, a lot of complaints were being received against police persons. साहब उसने फंसा दिया, देखिए इसको एक कट्टा कमा करके और आर्म्स एक्ट में बुक कर लिया. तो section 105 BNSS is a newly added provision which provides for recording of search and seizure through audio, video, electronic means. According to this provision, the process of conducting search of a place or taking possession of any property, article or thing under this chapter or under section 185, including preparation of the list of all things seized in the course of such search and seizure and signing of such list by witnesses. Remember it, signing of such list by the witnesses. So, the seizure list witnesses, when they are signing, there it has to be done, videography is to be done, shall be recorded through any audio, video, electronic means, preferably cell phone. And in recent workshop which was organized by the Department of Home, Government of Bihar, I had occasion to be there in that workshop. The DGP informed that steps have already been taken to purchase cell phones for each and every investigating officer of this state, so that they may be provided cell phone and they may be, some of them may be even trained to how to use that smartphone. So steps have already been taken. This is what we were told in that course. So preferably cell phone, and the police officers shall without delay forward such recording to the district magistrate, sub-divisional magistrate or the judicial magistrate of first class. वो ये नहीं कि खाली ले करके और रख लिया पॉकेट में, उनको सेल फोन पे लेना है ऑडियो वीडियो रिकॉर्डिंग, and it has to be forwarded to the jurisdictional magistrate. So, in fact, after coming into course of this law, ये जो अभी हो रहा है ना कि डायरी लिख रहे हैं एक बार एक महीने के बाद, चलिए पूरे महीने का लिख दिया, वो सब समाप्त हो जाए, वो पॉसिबल नहीं होगा, बिकॉज अभी उनको क्या है कि अब जो धीरे धीरे आप देखेंगे इसके अंदर तो डायरी रिकॉर्ड करना है, उनको ट्रांसमिट करना है, एंड वो कितने बजे रिकॉर्ड करेंगे डायरी, वो भी कंप्यूटर के वॉल पर वो टाइम आ जाएगा कि कितने बजे इन्होंने इस डायरी को लिखा है, कौन सी तारीख में लिखा है. Now, section 102 CRPC. Section 102 also we have dealt many times. Seizure of property. Now it is changed to section 106 BNSS. Now there is another newly added provision, that is section 107. This provides for attachment, forfeiture and restoration of property. Section 107 has its 8 subsections. According to this provision, where a police officer making an investigation has reason to believe that any property is derived or obtained directly or indirectly as a result of a criminal activity or from the commission of any offence, ये PMLA वाला provision 107, or derived from commission of any offence, he may, with the approval of the superintendent of police or commissioner of police, make an application to the court or the judicial magistrate exercising jurisdiction to take cognizance of the offence or commit for trial or try the case for the attachment of such property. Under subsection 2, the magistrate may, before or after taking evidence, issue a notice to such person calling upon him to show cause within a period of 14 days as to why an order of attachment shall not be made. This is compliance with the principles of natural justice. To give a notice. Subsection 4, considering the show cause, explanation, the magistrate may pass order of attachment in respect of those property which are found to be proceeds of crime. Where the magistrate would find that issuance of notice, this is emergency provision now, that in case of emergency, where the magistrate would find that issuance of notice would defeat the object of attachment or seizure, the court may pass an ex parte interim order directing the attachment or seizure of the property. Under subsection 6, the judicial magistrate may direct the district magistrate to relatively distribute such proceeds of crime to such persons who are affected by such crime. इसलिए वो जो property attach होगा, sale होगा, उसका जो proceeds वो किन लोगों को मिलेगा? Now provision says that distribute it relatively, proportionately among the victims. Victims of crime. Under subsection 7, on receipt of an order passed under subsection 6, the district magistrate shall, within a period of 60 days, distribute the proceeds of crime either by himself or authorize any officer subordinate to him to effect such distribution. where there is no claimant to such property or there is any surplus after satisfying the claimants, such proceeds of crime shall stand forfeited to the government. So first distribute it among the victims of the crime. Thereafter, if any surplus remains, then it will go to the government. Now, Chapter 8 of CRPC is providing for the provisions relating to security of keeping peace and for good behavior. Section 106 to 124 have been changed to Chapter 9 of BNSS 2023, and new sections are Section 125 to Section 143 respectively. There is no change in these provisions. So, all of us have been talking about 107 proceedings. 107 remains the same, only the section will change. And Chapter 8 of the CRPC is now Chapter 9 of BNSS. Now, in cases of public nuisance, Chapter 9 CRPC deals with these cases of public nuisance. Section 125 to 128 CRPC is now Chapter 10, Section 144 to 147 of BNSS. Section 135 CRPC changed to Section 154 BNSS. The words appearance or hearing may be permitted through audio video conferencing have been added in Section 154D of BNSS 2023. Thus, in a case of public nuisance, a person against whom an order has been made may appear in accordance with the order and show cause against the same, and such appearance of hearing may be permitted through audio video conferencing. So even in such cases of public nuisance, when it is initiated against someone, he may file his show cause and appear through video conferencing. In same chapter dealing with public nuisance, Section 138 CRPC is now Section 157 of BNSS. A proviso has been added to Section 157(3) of BNSS, which provides that the proceedings under Section 152 BNSS shall be completed within a period of 90 days. This is the timeline which has been fixed. 90 days. Earlier it was not there in CRPC. This 90 days may be extended up to 120 days in the BNSS. The another new provision in BNSS is Section 172. Under this section, all persons shall be bound to conform to the lawful directions of a police officer given in fulfillment of any of his duty under this chapter. And a police officer under this chapter means under Chapter 11. So, in fulfillment of any of his duty under this chapter, and a police officer may detain or remove any person resisting, refusing, ignoring or disregarding to conform to any direction given by him under subsection 1. रोड पर जो जुलूस निकालते हैं, उनको देखा सुबह में बस में भर करके ले गया, शाम को छोड़ दिया. तो दिस इज द प्रोविजन. पुलिस ने कहा आपको हट जाइए, आप नहीं हटे, आपको जबरदस्ती वहां से पुलिस करके बस में बिठा करके ले गया. सो एक कहता है पुलिस ऑफिसर में डिटेन और रिमूव एनी पर्सन under this provision it will be. And another important provision which has been now brought into BNSS is regarding zero effect. Chapter 12 of CRPC has been changed to Chapter 13 of BNSS, which deals with information to the police and their powers to investigate. Every day as a lawyer, as a judge, we are concerned with this provision. Now, under this chapter, means Chapter 13, the erstwhile Section 154 to Section 176 CRPC are Section 173 to Section 196 BNSS. So 154 to 176, now 173 to 196. The major changes under this chapter may be found in Section 173 of BNSS corresponding to Section 154 CRPC. Now, irrespective of the areas where the offence is committed, any information relating to commission of the cognizable offence can be given orally or by electronic communication. So now, you are not concerned with the jurisdiction of the police station. Any offence has been committed, you can inform about the commission of the cognizable offence orally or by electronic communication. If the information has been given by electronic communication, it shall be taken on record by the officer in charge of the police station on being signed within 3 days. Other electronic communications se aap kar rahe hain, then you have to make sure that within 3 days of that communication, you have to sign that. Everywhere you will find it. This has been now incorporated electronic communication as a mode, but you have to put your signature within 3 days. ऐसा नहीं कि 0 FIR आपने इलेक्ट्रॉनिक कम्युनिकेशन से कर दिया और उसको साइन नहीं किया, then it will not be registered. Thus, BNSS has now incorporated a provision for 0 FIR and lodging of FIR through electronic communication. Section 156 CRPC is now changed to section 175 BNSS. What is this? This is police powers to investigate cognizable case. And according to the proviso to subsection 1 of section 175, considering the nature and gravity of the offence, the superintendent of police may require the DYSP to investigate the offence. So now, in a particular case, considering the gravity of the offence, the DYSP may be made IO of the case. Any case. Till now you must have heard about the SC/ST Act cases. DYSP investigating the case. Now CRPC has incorporated a provision whereunder SP can, I will inform you that the Parliamentary Standing Committee had recommended, the earlier bill recommended that Superintendent of Police may himself investigate. But then the Parliamentary Standing Committee said no. Superintendent of Police is the head of the police in the district, so don't give him to investigate the case. He will be acting as supervisory authority. So that suggestion was accepted, and now only DYSP can investigate the matter at the instance of SP. Section 157 CRPC is now changed to section 176 BNSS. It is provided in subsection 2 of section 176 BNSS that the officer in charge of the police station shall forward the daily diary report fortnightly to the magistrate in the cases mentioned in clause A, B and first proviso to subsection 1. Subsection 3 has been inserted into section 176 of BNSS, and under this provision, quote, on receipt of every information relating to the commission of an offence which is made punishable for 7 years or more, the officer in charge of the police station shall, from such date as may be notified within a period of 5 years by the state government. This is another provision where the state government has to now notify the period within which the government in this regard caused the forensics expert to visit the crime scene to collect forensic evidence in the office. So the state government has to notify that within how much period the forensic experts should visit the crime scene and collect the forensic evidence of the offence. Let us see when this is notified. Now, and also cause videography of the process on mobile phone or any other electronic device, provided that where forensic facility is not available in respect of any such offence, the state government shall, until the facility in respect of that matter is developed or made in the state, notify the utilization of such facility of any other state. अगर आपके स्टेट में नहीं है तो आप दूसरे स्टेट से, आप भी हम लोग लेते हैं, दूसरे स्टेट से सर्विसेज लेते हैं, तो ये एक changes है. Now regarding confession, there is a change in the provision. Till now we have been hearing about section 25 of the Evidence Act. And now section 164 CRPC, which provided for recording of confession and a statement, is changed to section 183 BNSS. 164 statement होता है CRPC. Now it is changed to section 183 BNSS. There are some major changes in the new provision. Under the new provision, any magistrate of the district in which the information about the commission of any offence has been registered may, whether he has jurisdiction in the case or not, record any confession or statement made to him in the course of an investigation before the commencement of the inquiry or trial. Now, confession in course of investigation. If you read together with the provision of the Evidence Act, till now we know that confessional statement recorded before police is not admissible in evidence, except that 27 part of recovery, etc. Now, in course of investigation, police can take an accused to the magistrate, and in presence of magistrate, if he records his confessional statement, that will be admissible in evidence. A proviso has been added to subsection 1 of section 183 of BNSS, wherein any confession or statement made under this subsection may also be recorded by audio, video, electronic means. सब जगह दिखेगा, हर चीज में ऑडियो वीडियो इलेक्ट्रॉनिक मीन्स. These are safeguards to the accused also. In the presence of the advocate of the person accused of an offence, वकील के सामने ऑडियो वीडियो रिकॉर्ड वीडियो उसका कंडीशन. The second proviso of subsection 1 of section 183 of BNSS states that no confession shall be recorded by a police officer on whom any power of the magistrate has been conferred under any law for the time being in force. So, if any police officer has been vested with the power of a magistrate, he would not be competent to record confession statement under section 183 BNSS. He would not be qualified for this. Under subsection 4 of section 183, the confession has to be recorded in the manner provided in section 316 of BNSS. So read 183 with section 316 of BNSS. Clause A of subsection 6 of section 183, in cases punishable under section 64, 65 to 69 and other sections mentioned thereunder, the magistrate shall, these are the 64, 65 to 69 are the sections of the Bharatiya Nyaya Sanhita. Bharatiya Nyaya Sanhita, offences against the human. Now it says, cases punishable under section 64, 65 to 69 and the other sections mentioned thereunder, the magistrate shall record the statement of the person against whom such offence has been committed in the manner specified in subsection 5, as soon as the commission of the offence is brought to the notice of the police. Proviso to subclause 6A states that such a statement shall, as far as practicable, be recorded by a woman magistrate, and in her absence by a male magistrate in the presence of a woman. Because if you are recording a statement of a woman, she is the victim of crime, then the legislatures have ensured that it should be recorded by a woman magistrate. If she is not there, by a male magistrate in presence of her. So this is a safeguard. Now section 165 CRPC search by police officer is changed to section 185 of BNSS. Under this provision, again there is a very big change. Under this provision, the words, quote, provided that the search conducted under this section shall be recorded through audio, video, electronic means, preferably by mobile phone, have been added. So if the police officer is going for a search, he will have to keep his mobile phone on. He has to record that. Now section 167 CRPC, the procedure when investigation cannot be completed within 24 hours, this has been changed to section 187 of BNSS. There had been an amendment in section 167, subsection 2 of CRPC 1973. And now section 197, subsection 2 provides that the judicial magistrate to whom an accused person is forwarded under this section may, irrespective of whether he has or has no jurisdiction to try the case. So very important, irrespective of whether he has or has no jurisdiction to try the case, after taking into consideration the status of the accused person as to whether he is not released on bail or his bail has not been cancelled, authorize from time to time the detention of the accused in such custody as such magistrate inspect for a term not exceeding 15 days, in the whole or in parts, at any time during the initial 40 days or 60 days out of detention period of 60 days or 90 days, as the case may be, as provided in subsection 3, and if he has no jurisdiction to try the case or commit it for trial and considers further detention unnecessary, he may order the accused to be forwarded to a judicial magistrate having such jurisdiction. So these are the changes. Now under subsection 187, subsection 4 and subsection 5, a second provision has been added, which states that, quote, provided further that no person shall be detained otherwise than in police station, under police custody or in prison under judicial custody, or place declared as prison. So, a person may be detained only in a police station or in a place which has been declared as a prison by the central government or the state government. Nowhere else. You cannot detain any person at any other place. In case of a woman under 18 years of age, the detention shall be authorized to be in the custody of the remand home or recognized social institution. So, under the POCSO, even by judicial pronouncements, it has been established now that a woman under 18 years of age, she cannot be put in a police station. In fact, the Juvenile Justice Act clearly says that no juvenile shall be placed in the police station. So, that is the provision which has been taken into account. Now, section 173 CRPC, we all have discussed 173, final form, submission of police report. Now, it is section 193 BFWL. According to section 193, subsection 3, clause 2, the police officer shall within a period of 90 days, this is very important, now a new provision again, within a period of 90 days, inform the progress of the investigation by any means including through the electronic communication to the informant or the victim. The investigation investigation in relation to offence against women and children as provided under the BNSS and the POCSO Act are to be completed within 2 months from the date on which information was recorded by the officer in charge of the police station. So now the police officer is under a command of law that he has to inform the victim and about the progress made in course of investigation. He has to inform by electronic means. Now, power to further investigate a matter. Now this power has been conferred upon the court in course of that. As regards further investigation of the case, earlier provision 173 subsection 8 CRPC is now section 193 subsection 9 of the BNSS, and according to this provision, further investigation during the trial may be permitted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. So, the trial court has now been vested with this power. With the permission of the trial court, further investigation will be carried out. There were some decisions of the Honorable Supreme Court. There were some conflicting decisions also on this. So now, law has been taken care of it, and this has been specifically stated that in course of trial, this permission may be granted. Now, another major change, we all have heard about the complaint cases and the order taking cognizance. How order taking cognizance is passed. Now there is a major change. In the matter of complaint cases, chapter 15 of the CRPC is now changed to chapter 16 of BNSS. And a major change which has been effected is under section 223 of BNSS. Earlier there was no provision for giving an opportunity of hearing to an accused. कंप्लेंट आपने फाइल किया, 2 गवाही लगाया, हो गया, कॉन्फिडेंस हो गया, समन हो गया। और अगर SC ST एक्ट के अंदर लगा दिया तो कॉन्फिडेंस होने के बाद अपना डिवीजन बेंच जजमेंट है कि साहब एंटिसिपेटरी बेल नहीं मिलेगा, तो कंसीडर नहीं होगा। Now that situation has gone. Now before taking cognizance, the person against whom complaint has been filed, he will have an opportunity to represent himself. And it says, earlier there was no provision for giving an opportunity of hearing to an accused before passing of an order taking cognizance. But now, no cognizance of an offence under this section shall be taken by the magistrate without giving the accused an opportunity of being heard. This has been added in the form of proviso to section 223 subsection 2. Proviso to section 223. Subsection 2 has been added to section 223, which provides that the magistrate shall not take cognizance on a complaint against a public servant. Again, public servant have been protected. Public servant for any offence alleged to have been committed in course of the discharge of the official functions or duties, unless such public servant is given an opportunity to make assertions as to the situation that led to the incident so alleged. And the report, there are 2 safeguards. पहला क्या होगा? A report containing facts and circumstances of the incident from the officer superior to such public servant is received. तो पहले तो रिपोर्ट मंगाएंगे उसके सुपीरियर ऑफिसर से और इसको फिर सुनवाई करेंगे। Thus, the BNSS provides the safeguards and protection against frivolous and vexatious kind of litigations because of this subsection 2 of section 223 and proviso to section 223. It's a very important provision. Now, regarding timelines, in order to expedite an inquiry and trial, the BNSS has provided this timeline at many places. Briefly, you can take note of section 230 of BNSS, which replaces section 267 CRPC. Now, this has been amended and the words, quote, in no case beyond 14 days from the date of production or appearance of the accused, furnish to the accused and the victim, if represented by an advocate, have been added. Therefore, now once you appear in the court, you have to be made available. The police papers, etc. After cognizance, if you are appearing, and then in course of inquiry, police papers will be served upon you. That timeline has been provided. By virtue of section 231 of BNSS, supply of copies of the statement and documents to accused in other cases, tribal by court of session would be permissible in electronic form and shall be taken as duly furnished. Voluminous documents and फिजिकल कॉपी का बजाय आपको सॉफ्ट कॉपी दे देगा, and that will be taken as due service. Now there is another timeline regarding commitment of the case to the court of session. Section 209 CRPC. It's now changed to section 232 BNSS. A first proviso has been added to section 232D, which says that the proceedings under this section shall be completed within a period of 90 days from the date of taking cognizance, and such period may be extended by the magistrate for a period not exceeding 180 days for the reasons to be recorded in writing. So commitment to the court of session, maximum period 180 days from the date of taking cognizance. It cannot exceed more than 180 days. Under section 219 CRPC, 3 offences of same kind within a year could have been charged together. Now, in section 242 BNSS, the limit has been increased to 5. So 5 offences of the same kind within a year may be charged together. Section 227 CRPC, dealing with the discharge of an accused, is now changed to section 250 of BNSS. And under this provision, now accused can prefer an application for discharge within a period of 60 days. You cannot now file petition for discharge any time at your sweet will. You have to file this petition within 60 days from the date of committal under section 232. कमिटमेंट हुआ 60 दिन के अंदर फाइल कर दीजिए, अदरवाइज ना. Framing of charge section 228 CRPC is changed to section 251, and in the new provision the charge where offences are exclusively tried by court of session shall be framed against the accused within a period of 60 days from the date of first hearing of charge. So these are the provisions in which timeline has been introduced in order to expedite the trial. These timelines have been introduced. Now, evidence for prosecution, section 231 CRPC is now changed to section 254. Under the new provision, now the examination of witnesses may be held and recorded by audio, video, electronic means. So, now you are not required to call the witness in the courtroom. If the facilities are developed, many things are to be done for this. From where the witness will depose, who will be the nodal officer present there, in whose presence he will depose so that he cannot be deterred. Many things are to be taken care of, but now there is a provision. The witnesses are not required to travel all the way from far distant places, and their evidence may be recorded through audio-video mode. Under subsection 2 of section 254 of the BNSS, the deposition of evidence of any public servant may be taken through audio, video, electronic means. Now, judgment of acquittal or conviction, 235 CRPC, is changed to section 258 of BNSS. Subsection 1 of section 258 provides that judgment to be delivered within a period of 30 days from the date of completion of arguments, which may for a specific reasons be extended to a period of 45 days for reasons to be recorded in writing. Now, in the cases instituted otherwise than a police report, means complaint cases, subsection 7 has been inserted to section 269 of BNSS, which provides that but despite giving opportunity to the prosecution and after taking all reasonable measures under the Sanhita, if the attendance of the prosecution witnesses under subsection 5 and 6 cannot be secured for cross-examination, it shall be deemed that such witness has not been examined for not being available, and the magistrate may close the prosecution evidence for reasons to be recorded in writing and proceed with the case on the basis of the materials on record. This is again to expedite the trial. Don't keep on giving adjournments. The provisions relating to summons trial and summary trials have been slightly changed. Under section 274 of BNSS, the words Quote, provided that if the magistrate considers the accusation as groundless, he shall, after recording reasons in writing, release the accused, and such release shall have the effect of discharge, have been added in form of proviso to section 274. Therefore, at the outset, if the magistrate considers the accusation as groundless, he can release the accused, and that will be taken as his discharge. In case of non-appearance or death of complainant, section 256 CRPC, now the court can acquit the accused after giving an adjournment for a period of 30 days to the complainant to intervene. किस दिन का एक complainant को notice देंगे, किस दिन का notice देकर के उसको close कर देंगे. In the cases of plea bargaining, earlier there was a time limit of 60 days for filing an application for plea bargaining from the date of framing of charge, but now it has been reduced to a period of 30 days. So if you want to go for plea bargaining, file an application within 30 days only. Now, there are some changes with regard to the mode of taking and recording of evidences. One major change has been effected by section 308 BNSS, which replaces section 273 CRPC. The words including through audio, video, electronic means at designated place to be notified by the state government. This is what I was talking, that how to record the evidence of a witness, from where the witness will depose, who will be the nodal officer present there. So that has to be notified by the state government. So designated place is to be notified by the state government. Now under section 281 CRPC, which is now section 316 of BNSS, an accused who is in custody may be examined through electronic communication, and in such circumstances, signature shall be taken within 72 hours of such examination. So he may be examined from jail through electronic communication, or within, and only requirement is that within 72 hours his signature has to be obtained. The BNSS has dispensed with the requirement of formal proof. This is very important. Section 330 BNSS. अभी तक जो गवाही सिखाया जाता था ना, न्यू इंटेंट ऑफ द बार जो आए उनको बोला अच्छा ये डॉक्यूमेंट कैसे एग्जीक्यूट होगा, तो ट्रायल कोर्ट में वो सिविल कोर्ट में सीखना पड़ता था हम लोगों को कि साहब बोलिए इसको दिखाई कि देखिए साहब यही वो कॉपी है नोटिस का जो कि 3 प्रति में कार्बन कॉपी तैयार की गई थी, फलाने व्यक्ति ने इसको टाइप किया था, ये फलाने व्यक्ति का सिग्नेचर है जिसको हमने पढ़ते लिखते हुए देखा है, हम उसके सिग्नेचर को पहचानते हैं। और ये जब तक बोलना आप नहीं सीखे और पूछना नहीं सीखे गवाह से, वो डॉक्यूमेंट आपका एग्जीक्यूट नहीं होगा। दिस वाज अ वेरी डिफिकल्ट लर्निंग एट द बार, एंड we had to learn it somehow. Now, the lawyers should be happy that those formalities have been almost dispensed with, have been done away with. How? See, according to section 330 of BNSS, where any document is filed in a court, the parties have to admit or deny the genuineness of such documents soon after supply of such, just like arbitration proceeding हो गया ना, दोनों पार्टी ने डॉक्यूमेंट्स फाइल किया, बोला ठीक है तुम इसको देख लो, एडमिट करते हो कि डिनाई करते हो, जितने डॉक्यूमेंट को एडमिट किया वो एग्जीक्यूट मार, तो कट शॉर्ट हो गया। अब ये प्रोविजन ले आए इन्होंने, एंड इन नो केस इट शुड बी लेटर देन 30 डेज, 30 दिन के अंदर डॉक्यूमेंट फाइल कीजिए, एडमिट कीजिए, डिनाई कीजिए, जो एडमिट किया वो एग्जीक्यूट हो जाएगा। Admitted documents shall be read in evidence without requirement of proof of signature of the author of the documents. This is very important. You are not required to say कि साहब ये फलाने व्यक्ति का दस्तखत है और उसको हमने पढ़ते लिखते देखा है, उसके दस्तखत को हम पहचानते हैं, ये वही दस्तखत है और तब जाकर के वो एग्जीक्यूट मार्क होगा, इसकी जरूरत नहीं। If the document is admitted, accurate. The court has got discretion to relax the time limit with reasons to be recorded in writing. Then there is another provision in this that no expert is to be called to appear unless his report is disputed. Therefore, if a postmortem report is to be exhibited, only for purpose of exhibiting the document, presence of the doctor who has signed the postmortem report would not be required. It is only when you say that no, I dispute this report. If you are disputing the report, then his presence should be required. Otherwise not. So this is another major change. Now a new section 336 has been added in BNSS, which provides for evidence of public servants, experts, police officers in certain cases. This provision takes care of such situations where the public servant, expert or officer is either transferred, retired or died or cannot be found or is incapable of giving the position. अभी पुलिस ऑफिसर्स नहीं मिल रहे, रिटायर कर गए, डेथ हो गया, केस पेंडिंग है, अब उसकी जरूरत थी। अब जो भी उसका सक्सेसर इन ऑफिस होगा, वो आकर के डिपोज करेगा and that document will be added. There will be no need of these actions. First provided to section 336 states that no public servant, scientific expert or medical officer shall be called to appear before the court unless the report of such public servant, scientific expert or medical officer is disputed by any of the parties of the trial or other proceedings. The second proviso to section 336 states that the deposition of such successor public servant, expert or officer may be allowed through audio, video, electronic means to use. तो जो सक्सेसर होगा एक थानेदार नहीं है, दूसरा जो वहाँ है वो ऑडियो वीडियो मीन्स से डिपोज करेगा and that document will be proved. Now another new provision which has been added in BNSS is section 356, which provides inquiry or trial being held in absence of proclaimed offender. ये प्रोविजन नया लाया गया, अभी जो थे कि प्रोक्लेम्ड ऑफिसर हो गए सेक्शन 299 300 वो जब पकड़ाएगा तब फिर रिकॉर्ड्स प्लेस होगा और फिर आगे कार्रवाई होगी। अब नहीं, अब कहता है कि अगर उसका इमीडिएट अरेस्ट नजर नहीं आ रहा है तो नाउ लॉ सेज that it shall be deemed to operate as a waiver of the right of such person to be present in person, and the court shall, after recording reasons in writing, in the interest of justice, proceed with the trial in the like manner and with like effect as if he was present. So the law has now said that if he is not present, he is absconding, we will not give him any benefit. Law will presume that he has got knowledge of everything, and the trial will continue as if he is present in course of trial. Another new section, section 398 has been added in BNSS, wherein every state government shall prepare and notify a witness protection scheme. अपने आप ये है witness protection scheme. Now it has been made mandatory. Now, section 417 BNSS replaces section 376 CRPC. There is a change in term of imprisonment from 6 to 3 months. This provision deals with no appeal in petty cases where a high court passes only a sentence of imprisonment for a term not exceeding 3 months or fine not exceeding 1,000 or both for such imprisonment and fine, there would be no appeal. Appeal का provision 378 changes to 419. Now, appeal against conviction in certain cases by High Court. 379 CRPC changes to section 420 of BNSS. बस हो गया प्लीज. In BNSS section 472, this provides for the mercy petition in death sentence cases had been introduced. अभी तक हम लोग आर्टिकल 72 एंड 161 of the Constitution. I have my doubts. इस provision को थोड़ा देखिएगा आप लोग. Whether a period of limitation can be imposed on the power of the President and the Governor and the matter of consideration of the mercy petition. What has been done by incorporating section 472, it says under this provision a convict under the sentence of death for his legal heir or any other relative may file a mercy petition before the President of India under Article 72 or the Governor of the state under Article 161 of the Constitution within a period of 30 days. ये एक limitation लगा है. Is it? I have my doubts subject to further discussions and what the law is finally settled on this. Whether such limitation may be imposed on the power of the President and the Governor in the matter of consideration of an application which is by way of a mercy petition. This is a food for your thought, just think over it. 30 days from the date on which superintendent of date one informs him about the dismissal of appeal or a special leave to appeal by Supreme Court, or two informs him about the date of confirmation of the sentence of death by the High Court, and the time allowed to file an appeal or a special leave to Supreme Court has expired. Now, power to commute sentences. Section 474 BNSS replaces Section 433 CRPC. Every day we are discussing revision and then premature release. Under this provision, there has been a change with reference to terms of imprisonment. The appropriate government may, without the consent of the person sentenced, commute death sentence for imprisonment for life, a sentence of imprisonment for life for imprisonment for a term not less than 7 years. C. A sentence of imprisonment for 7 years or more for imprisonment for a term not less than 3 years. A sentence of imprisonment for less than 7 years or fine, and a sentence of rigorous imprisonment for a simple imprisonment for any term to which that person might have been sentenced. These are the powers conferred upon this state. Section 479 of BNSS replaces 436A. 436A CRPC. According to Section 479, maximum period for which an under trial prisoner not in case punishable with death or life imprisonment may be detained would be 1/2 of the maximum period of imprisonment. But whereas such person is a first time offender who has never been convicted for the offence in the past, he shall be released on bond by the court if he has undergone detention for a period extending up to 1/3 of maximum period of imprisonment. So, as an under trial, if it is his first offence and it is not in relation to a case punishable with death or life imprisonment, he has undergone 1/3 of the maximum sentence, then release him on. So, these are the major changes. How the CRPC is now being replaced by BNSS. So, in short, I have tried to cover all the provisions. Thank you.
Thank you, Your Lordship, for sharing priority insights. If anybody have any question, can ask. Come in the front and just ask.
He has got some sections. Shantanu can come forward.
See, at the outset, I'll tell you one thing. What's your name? Priya. Priyanka, while introducing me, said about many things about me, and she said I have done a lot of cases in civil, and then she said in criminal matters also I have done. Then I was checking on my mobile, my profile which I have placed on the High Court website. I said कि कहीं हमने ये तो नहीं लिख दिया कि criminal भी हमने किया है. Then I was checking that, you must have noticed कि criminal इन्होंने कहाँ से कर लिया कि but I am happy कि हमने अपने प्रोफाइल में ये नहीं लिखा है कि हमने criminal matters किया.
It can't be denied. It can't be denied that criminal matters still you are doing as your lordship can't be said because you are not the practitioner of criminal law.
I tell you one thing very honestly. When I was a student of law, I had always secured distinction in criminal law. I had secured very less marks in company law. But when I joined practice, my practice flourished more in the corporate side and not in criminal side. I was not getting any grief from the criminal side. I was unable to lead the lawyers in the civil court. I was unable to lead the civil courts. Therefore, I was not getting any criminal matters. So I have see my profile on the High Court website. I have not claimed even that I have done criminal matters.
My lord, please forgive me for that.
I want
being a gentleman or being done very
No,
well.
that's why I told you that I never feel shy of doing criminal matters. As a judge, you have to do everything, whatever you get, you get. So I also did criminal matters, but my introduction will never go with as an expert in criminal matters.
But this time we have privileged to know all of the book of BNSS right now.
That is a learning process. Now you have to keep on learning. You have to keep on learning. If you believe in learning, then nothing is impossible. I said it just to safeguard me. Sadhguru should not test me.
Because I am getting more religious than this in revision matters.
He is doing a lot of revision matters.
While reading some new changes, I found two interesting changes at BNSS while IPC. May I read that for you? I am not making any opinion on that, and I hope that all of you may read, learn, and enlighten. Section 285, newly added section. Whoever being a public servant, corruptly or maliciously makes or pronounces any stage of judicial procedure, any report, order, verdict, or decision which is known to be contrary to law shall be punished with imprisonment of either description for a term which may extend to 7 years or with fine or with both. My apprehension is that judicial officers and quasi-judicial officers time may come that any executive decision may allow them into these frameworks just because the very
Wait for the 1st of July and telling the otherwise.
I will say. May I read the second? May I read the second?
Yes, yes.
Section 256. Whoever being in any office which gives him legal authority to commit persons for trial or to confinement, or to keep person in confinement, corruptly or maliciously commits any person for trial or to confinement, or keeps any person in confinement in the exercise of that authority, knowing that in so doing he is acting contrary to law, shall be punished with imprisonment of either description for a term which may extend to 7 years or with fine or both. That is exclusive, in my opinion, that is exclusive for the judicial officers. Because definition of public servant includes every judge, including any person empowered by law or to discharge whether by himself or as a member of any body or person any adjudicatory functions. That is my apprehension that newly added sections in IPC will bring paradox in those cases. Third, likewise section 257 and 258 is also very much contrary to interest of judicial persons having which are going to pass any law. Definitely. But right now I am having a apprehension about that. That we as a lawyer may take it as a tool.
That is true, but law is always developing. And in government of our country, the constitution, so we interpret the law within the constitutional boundaries. If it is against the constitutional protection provided to the
Judicial officer.
judicial officer or the public servant, it comes in conflict with other provisions of the law.
Because the language which is incorporated, that does not face. The word used is report, order. That is fine. Then verdict or decision. That is very much obvious.
Sir,
Again, being in any office, it gives you legal authority to commit persons for trial or to confinement. I think this is coming of judicial officers right now for future laws. Thank you. Thank you.
Anybody else have any question?
It is long time that my मेरे हुआ है से बेनिफिट ज़्यादा नजर आ रही है टाइमलाइन
मुझे टाइमलाइन से यार ना और ज़्यादा उम्मीद नहीं करना मुश्किल है, इसलिए कि आप देखेंगे बहुत सारे स्टैट्यूट केस इसमें टाइमलाइन फिक्स है। अल्टीमेटली इट इज अबाउट द इंफ्रास्ट्रक्चर। आप हम चाहते हैं कि खूब केसेस डिस्पोजल करें। I am also a human being. आप इतना एक्सपेक्ट करते हैं मुझसे, आपको ये देखना होगा कि जो नंबर ऑफ केसेस है और जो हमारा इंफ्रास्ट्रक्चर है उसके अंदर ये कह देने से कि 60 दिन में हो जाएगा या 180 डेज में ये हो जाना चाहिए, संभव नहीं। आप देखिए ना, छोटा सा आपको स्टैट्यूट देते हैं, कंज्यूमर प्रोटेक्शन एक्ट। कंज्यूमर प्रोटेक्शन एक्ट जब आया तो उसके अंदर 90 डेज का टाइम लिमिट, 90 डेज में डिस्पोजल। अभी आप जाइएगा नेशनल कमीशन में भी तो आपको 4 से 6 महीने का डेट मिलेगा एक केस। तो वही इसलिए कि आप जो सोच रहे हो 22-20 से पैसा होता नहीं है, तो सोच लिया और वो हो गया। अल्टीमेटली यू हैव टू डिलीवर। आप बहुत सी चीजों पर डिपेंड करता है, देखते हैं टाइम के साथ।
इसी का मोरल लेस ऐसा ही कुछ
जिसको 2015-16 में मेंटेनेंस मिला है, तो जब उसके हस्बैंड को पूछते थे कि आपको दे रहे हैं कि नहीं, तो नहीं साहब मेरा फाइल कर रखा है। क्या हुआ? इस लेडी को 2000-3000 रुपया मिला मेंटेनेंस का और उसका 10 साल रिवीजन पेंडिंग रह गया हाईकोर्ट के अंदर। आते आते अल्टीमेटली क्या हो, आप यही मोटर व्हीकल एक्सीडेंट केसेस वहाँ भी हमने देखा, जो मिसलेनियस अपील्स की सुनवाई कर रहे थे, तो मोटर व्हीकल के केसेस में जो हमने देखा कि young lady with her 2 daughters were injured in an accident. Her husband had died in that accident. And उन्होंने पिछले 12 साल से वो लड़ाई लड़ रहे थे, वो उनको 1 रुपया नहीं मिला, because even though they had succeeded, insurance company had prepared an appeal. ये जो टाइमलाइन का इशू है, this has to be looked into from different
सोसाइटी में वकील बारे में बोले
आप वकील बोलते हैं और हम एज ए जज हमारा डिस्पोजल होता है, तो हाईकोर्ट के ऊपर आपका एक ब्लॉक लगा हुआ है, ब्लॉक कितना केसेस हाईकोर्ट में डिस्पोजल हुआ, कितना फाइलिंग हुआ, ये सब आता है। आप जब हमारे कोर्ट में आते हैं और हम जल्दीबाजी दिखाते हैं तो आप कहते हैं देखिए आप सुने ये तो बड़ा गड़बड़ है, बस नहीं सुने पूरा, हम फील करते हैं। एट द एंड ऑफ द डे आपको जब सुनने में हम समझ लेते हैं, मालूम होता है कि साहब दिन भर में तो ये देखिए मुश्किल से 10 केस हुआ, यहाँ फाइलिंग का रेट जो है 25 है और हम 10 केस कर रहे हैं, तो 15 केस का प्रेगनेंसी हो रहा है, किसको दोष दीजिएगा, आपको हम दोष दें या आपको आप दोष दें? ये सब नहीं है, दोनों पक्ष को जानिएगा, तभी आपका एक बैलेंस व्यू आएगा। हम भी जब वकील होते थे तो हमको लगता था कि साहब जज को क्या काम होगा, 4 रुपये मिले उसके बाद क्या करना है, सबसे काम करें, आराम करना है। बट वो इधर आने के बाद पता लगा कि 4:15 बजे के बाद बैठ करके और फिर रात को 8 बजे तक क्या क्या करना होता है हाईकोर्ट में। दोनों पक्ष को जब जानिएगा तो बात का एक बैलेंस हमारे भी सोच नहीं थी जब हम इधर आने के बाद दोनों पक्ष जानने का मौका मिला, थोड़ा उधर ये टाइमलाइन से आई एम नॉट वेरी इम्प्रेस्ड, पर ठीक है, एक एफर्ट है, कोशिश तो है।
Every case will have its own requirement. There will be cases जो तुरंत 2 मिनट में हो सकता है, there will be cases which can take a whole day for adjudication.
स्टडी कर रहे हैं, बहुत वर्षों से चल रही है, कमेटी है सुप्रीम कोर्ट की कमेटी है, अब इसमें की बहुत दिनों से चल रही है कि हमको कितना स्ट्रेंथ चाहिए ट्रायल कोर्ट में जजेस का, और उसमें हम लोग ये स्टडी कर रहे हैं कि सिविल मैटर से एक सूट अगर आएगा तो एक पार्टीशन सूट को डिसाइड करने के लिए एक जज को कितने घंटे समय चाहिए, अब उसका हम निकालेंगे कि एक जज से हम होल डे में कितना घंटा एक्सपेक्ट करते हैं कि वो काम करें, उसके बाद निकालेंगे कि एक सूट के डिस्पोजल में कितना घंटा लगेगा अगर दोनों कंटेस्ट कर रहा है पार्टी तो, और तब उसका परफॉर्मेंस हम निकालेंगे कि उस जज को कितना दिन लगेगा एक सूट को डिस्पोजल करने, और एक सूट का डिस्पोजल करने में जितना लगेगा उसके हिसाब से आप मल्टीप्लाई कर दीजिए कि कितना रिक्वायरमेंट ऑफ जजेस आपको प्रॉब्लम तो है।
आपने तो सोशल इम्पैक्ट असेसमेंट
होना चाहिए, आपका जैसे आप मान लीजिए लीगल केसेस आ रहे हैं, I had occasion to know it when I was in the areas committee of the High Court. In 2016 में जब लॉ आया, उसके ठीक पहले हमारे यहाँ 66,000 फाइलिंग्स थे क्रिमिनल केसेस, and within 1 year that went to about 98,000 or 99,000 initial period, and then in inspecting judge, I noticed in all the trial courts, छोटे छोटे ट्रायल कोर्स में भी 12,000 से 15,000 ट्रायल्स पेंडिंग हो गए। हमारा एक ऑफिसर जो है जुडिशियल ऑफिसर, वो कितने तरह का स्पेशल जज है आप देखिए, SC ST देखना है, उसको NDPS देखना है, आप गिनते जाइए अपनी पर, आपको पता लगेगा कि साहब किस्मत अच्छा था कि हम जज नहीं। नहीं तो ये टेंशन में जो है हमने ऐसे कहा लाइटली कहा, मुझे लगता है आपके बारे में भी अच्छा है कि नहीं तो परेशान हो जाता है। ये ऐसा चीज है कि तो हमको किस नहीं किया ये
The new BNSS has made compulsory forensic examination for the offences more than 7 years. So would it be a confusing factor as we are not tied up with the infrastructure?
That is why the statute says कि अगर इंफ्रास्ट्रक्चर नहीं है आपके पास तो आप दूसरे स्टेट से भी वो तब तक लीजिए जब तक आपके पास नहीं है।
And would it amount to discrimination? Any offence which requires forensic examination?
डिस्क्रिमिनेशन आप देख लेंगे NDPS में बिना FSL रिपोर्ट का चार्जशीट फाइल हो जा रहा है, बिना FSL रिपोर्ट का चार्जशीट फाइल हो रहा है कि नहीं हो रहा है। हमने एक केस में रिपोर्ट भी किया है, आप देखेंगे that police officer stated in court in front of this defendant of case साहब इसको बेल होने वाला था इसलिए हमने चार्जशीट फाइल कर तो सिस्टम की बात कर रहे हैं इसीलिए।
The interpretation of Hon'ble Supreme Court in the light of latest judgment, what is the position after 1st July? Because lot of the conflicting factors will be coming up.
No, what conflict?
The timeline factor, because after the launching of FIR will be changed from 1st July, because 33 offences have been
Not will be applied from 1st of July. It will be a smooth transfer, smooth.
It's for police to launch. No FIR will be, because lot of provision has been deleted from the 124A. What happened in section 66A of IT Act?
That has already been done away with. Why 66A should be there? That has already been done away with. And
Lot of FIR has been filed.
And
How to root out the law?
the Supreme Court held 377 IPC, 497 IPC ultra-virus.
Yes.
No. Parliamentary Standing Committee, I tell you, had recommended the state that these two provisions be incorporated in the Bharatiya Nyaya Samhita. First 377, Navtesh case, Lord's case, and 497. Both the judgments, but the government did not agree to the Parliamentary Standing Committee views. And 377, 497 are no longer there in the Bihar National. And this Bharatiya National. Law तो चलेगा, already उसको
अभी तो फाइलिंग में सेक्शन कौन कौन सा चेंज करना है वो दिख रहा है। रनिंग फिफ्टी का 75 लगेगा।
1 जुलाई से डिस्कशन अच्छा है कि शुरू कर दिए हैं। Even I am learning. मेरे सामने तो ज़्यादा प्रॉब्लम होता है कि हमको और ये सब क्रिमिनल वगैरह जो है वो ज़्यादा नहीं करते थे तो मेरे लिए और इम्पोर्टेंट है कि जल्दी पर ठीक है।
Now I would like to request our patron Priyanka Sharma ma'am to give a vote of thanks.
I, on my behalf and on behalf of the Federation of Bihar Traditional Women Lawyers, thank Hon'ble Justice R. Prasad for his detailed and delightful speech. I would like to express my deepest appreciation to Hon'ble Justice R. Prasad for his meticulous insight and enlightening address to the August gathering. Your honor, profound understanding of law combined with an unwavering commitment to justice has illuminated the path forward for us all. Your guidance on the interactions of the Bharatiya Nagrik Center and the timeline it establishes for the protection of our citizens is invaluable. Moreover, your elucidation of the admissible evidence and the Bharatiya Sanction Adhiniyam has provided us with clarity and direction needed to navigate the new era of jurisprudence. To the members of the judiciary and the law enforcement present here today, your adaptability and commitment to upholding these new laws are essential for their successful implementation. The road ahead may be challenging, but your dedication to serving justice will undoubtedly lead us to this transition. Furthermore, I would like to thank the organizers of the workshop for creating a platform with your ideas and the knowledge about the groundbreaking changes can be shared and discussed. Your efforts in facilitating the dialogues are crucial for the smooth adoption and understanding of the new legal provisions. Moreover, I would feel that Hon'ble Justice Mr. Rajiv Prasad has given us a lot of clarity on the new law. And what will be the changes, we don't know, and how it will be implemented, that future will. But I think he has clearly explained everything. There is nothing more to explain about that. He has taken that much of time that all of you are taking that time, and now I think all of you are tired, so I will not go further. I once again thank all of you and Honorable Justice Rajiv Prasad for giving us so much time to just make us clear about the law. And I think it is easy for us to go through that path.